Getting a divorce in New York is actually much more simple than you might think. Under New York divorce law, one spouse must be a resident of New York for 2 years before a divorce can be filed. However, that restriction can be reduced to 1 year if the spouses were married in New York and either spouse is still a resident. They once resided in New York as husband and wife and either spouse is still a resident, or the grounds for divorce arose in New York and either spouse is a resident of the state of New York. In addition, there is no residency time limit requirement if both of the spouses were residents of New York at the time of filing the divorce and the grounds for divorce arose in New York. Once the residency requirements is completed, a legal grounds for a divorce must be established. In New York, both general and no-fault divorce are acceptable grounds for divorce. The no-fault reasons for a divorce in New York are: the relationship between husband and wife has broken down irretrievably for a period of at least 6 months, while the reasons for a general divorce are adultery, abandonment for 1 year, imprisonment for 3 or more consecutive years, and cruel and inhuman treatment, conversion of a separation judgment, conversion of a written and acknowledged separation agreement after living separate and apart for more than 1 year. New York does not require a parenting plan when deciding matters of child custody. Joint or sole custody is to be determined according to the best interests of the child. Neither parent is entitled to custody over the other. Additionally, there are no factors specified in the statute which dictate the circumstances around child custody matters. With regards to child support, health insurance coverage may be ordered to be provided. Marital misconduct of either parent is not to be considered in child support decisions. There are specific child support guidelines in the statute and which are presumed to be correct unless there is a showing that the amount of support would be unjust or inappropriate. The factors to be considered are the financial resources of the child and the parents, the standard of living the child would have enjoyed if the marriage had not been dissolved, the physical and emotional health of the child and any special needs or aptitudes of the child, the financial resources, needs, and obligations of both the non-custodial and the custodial parent, the tax consequences to each parent, the non-monetary contributions that the parents will make towards the care and well-being of the child, the educational needs of either parent, whether one parent's income is substantially less than the other parent's, the needs of other children of the non-custodial parent, if the child does not receive public aid, any extraordinary expenses required for the non-custodial parent to exercise visitation rights, and any other relevant factors. Security may be required for the payments. When it comes to property distribution, New York is an equitable distribution state. Separate property, including property acquired before a marriage and any gifts or inheritances whenever acquired, is to remain with the spouse who owns it. Separate property also includes any increase in value or property acquired in exchange for separate property. Marital property acquired during the marriage will be equitably divided between the spouses, based on the following factors: the contribution of each spouse to the acquisition of the marital property, including the contribution of each spouse as homemaker, the income and value of each spouse's property at the time of marriage and at the time of filing for divorce, the probable future economic circumstances of each spouse, the length of the marriage, the age and health of the spouses, the amount and sources of income of the spouses, the probable future financial circumstances of each spouse, the potential loss of inheritance or pension rights upon dissolution of the marriage, whether the property award is instead of or in addition to maintenance, custodial provisions for the children and the need for a custodial parent to occupy the marital home, the type of marital property in question, whether it is liquid or non-liquid, the impossibility or difficulty of evaluating an interest in an asset such as a business, profession, or corporation, and the desirability of keeping such an asset intact and free from interference by the other spouse, the tax consequences to each party, the wasteful dissipation of assets, any transfer of property made in anticipation of divorce, any equitable claim that a spouse has in marital property, including joint efforts and expenditures, and contribution and services as a spouse, parent, wage earner, and homemaker, and to the career and career potential of the other spouse, and any other factor necessary to do equity and justice between the spouses. Marital fault may be considered. Financial disclosure of assets and income are mandatory. Either spouse may be awarded maintenance without regard to marital fault based on a consideration of the following factors: the income and property of the spouses, including any marital property divided as a result of the dissolution of marriage, the length of the marriage, the age and health of both parties, the present and future earning capacity of both parties, the need of one party to incur education or training expenses, the existence and duration of a premarital joint household or pre-divorce separate household, acts by one party against another that may have inhibited or continue to inhibit a party's earning capacity or ability to obtain meaningful employment. Such acts include, but are not limited to, acts of domestic violence as provided in Section 459A of the Social Service Law, any transfer of property made in anticipation of divorce, the wasteful dissipation of marital property, the contribution of each spouse to the marriage and the career of the other spouse, including services rendered in homemaking, child care, education, and career building of the other spouse, the tax consequences to each spouse, the ability of the spouse seeking support to become self-supporting, and the time and training necessary, any reduced lifetime earning capacity as the result of having foregone or delayed education, training, employment, or career opportunities during the marriage, the presence of children of the marriage in the respective homes, the care of the children or stepchildren, disabled adult children or stepchildren, elderly parents or in-laws that has inhibited or continues to inhibit a party's earning capacity, the inability of one party to obtain meaningful employment due to age or absence from the workforce, the need to pay for exceptional additional expenses for the children, including but not limited to schooling, daycare, and medical treatment, the equitable distribution of marital property, the loss of health insurance benefits upon dissolution of the marriage, and the availability and cost of medical insurance for the parties, and any other factor the court deems just and equitable. Finally, New York has no divorce mediation requirements or provisions. To find out more, visit us today at www.mydivorcepapers.com.